Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office, and joining me today is partner and attorney Angelita Chavez from our Kennewick, Washington office. Hi there, Angelita, and welcome.
Hi there, Arianna. Thank you so much for having me on today. I really appreciate that.
Thank you for being here. For today's topic, we're going to be discussing knowing your rights in removal proceedings. We're going to cover all the pressing questions we get on this topic, so make sure you stay tuned till the end. Before we begin, just a quick reminder that we are live on YouTube, LinkedIn, and Facebook. This conversation is for informational purposes only. It does not create an attorney-client relationship. So please, if you have questions, comment them below or email us at info@chug.com so we can help you out. So let's get into it, Angelita. Let's start with the basics. What is an NTA notice to appear? Can you tell us a little bit about that?
Thank you, Arianna. Great question to start with. An NTA, notice to appear, also known as an NTA, is a document that is essentially the initiation of removal proceedings, and it requests a person to show up generally to immigration court. So that's just the really short of it, but there are some other important aspects of the NTA as well.
Okay, so someone gets this notice, they have to appear in court. What information should someone pay attention to when they get this type of notice?
Yeah, so once someone gets a notice to appear, again, their removal proceedings have been initiated, there are several important pieces of information that they should be able to take from that NTA. Number one is that your NTA will have what's called an alien number, also known as an A number, that is usually located at the upper right-hand corner, if you're looking at the document, right below the actual title of the notice to appear. The alien number is an important reference number to know because it's an identification number that can be used to look up case status on a case, for example, that's before EOIR, before immigration court. So it's a really important piece of information to know because that is going to be your alien number. It's going to be your identification number that's going to follow you throughout your removal process. And even if you are able to get immigration relief and apply for lawful permanent resident status or citizenship, that's the same number that's going to be your identifier number. Another important piece of information that the notice to appear usually has is the time and date of the immigration proceedings. So there should be a time and date located, or this will be issued at a later time. So it's always very important to take a look at that, take a look at when these dates are going to be coming up, because there are some consequences of failing to appear to your immigration court, which I know that you'll be asking me some questions about that, so we can discuss that more later on. But last but not least, the other third aspect that's important of the NTA is actual charges. The NTA usually includes a statement as to why you are somebody who is removable. For example, it'll state that you are not a citizen or national of the United States, that you are a native of whatever particular country that you're a native of, and that you entered the United States at a certain date and time, and the reasons why you might be removable. This could be because you might have overstayed a visitor visa, or you might have had some violations of your non-immigrant visa status, or maybe there are certain crimes that were committed that make you removable from the United States, or you might have entered without inspection at a port of entry, or unlawfully, and therefore without inspection, and that could also make you removable from the United States. So there are obviously many reasons why somebody could be in removal proceedings, but generally those reasons should be stated in the charging statement in that document of the notice to appear.
That's really great to know. So if you did receive a notice to appear, make sure you are looking for those important items that Angelita just mentioned. It is really important to pay attention to those and keep track of the dates that you have on there. And definitely, if you have questions about anything, reach out to your attorney regarding this process. So Angelita, if someone is in removal, for example, does that mean that they always get detained, or is it possible to be in removal without having been placed in custody? Can you touch on that for us?
Yes, really great question. Thank you for asking that, Arianna. When someone is put in removal proceedings, I know it could be very scary, obviously, for anybody in this situation. But you don't always you're not always going to be put in an actual detention facility. Some folks are put in a detention facility depending on how they came into contact with ICE or they came into removal proceedings, whether it was maybe an immigration raid or whether they were apprehended at a port of entry or trying to cross the United States borders unlawfully. It really depends on what the situation is, that somebody could be put into detention, or maybe there was some sort of crime that was committed. Then the person had to go into detention and be held there for some time. But more often than not, a person can still be put into removal proceedings without ever having to step into a detention facility. Regardless, once they get that NTA given to them by the authorities, then at that point in time, they are in removal proceedings, regardless of whether they ever stepped foot into a detention facility. So all it means that person now must appear before an immigration judge at some point in time, based on that notice to appear or later appointments that are given by the court.
That's really good to keep in mind. Thank you for sharing that. For everybody who's just tuning in, just a quick disclaimer, we are live on YouTube, LinkedIn, and Facebook. This conversation is for informational purposes only. It does not create an attorney-client relationship. So please email us if you have questions or comment them below, and we'll do our best to help you out. We are discussing knowing your rights in removal proceedings for everyone just tuning in. Let's get back into it, Angelita. So what should someone expect when they show up to an immigration court hearing? What do we need to know?
Yeah, great question. So if you have your date, you know when you have to appear and where you have to appear to immigration court. Usually when you go into that immigration court, it could be in Seattle, it could be in LA, it could be, wherever it is that you were called upon to appear before an immigration judge. Know that you want to be on time, right? You always definitely want to be on time. You want to make sure that you're there at least within a few minutes. Some immigration courts might have a very long line, like LA, for example, I know can have super long lines to get into the buildings, potentially if there's a lot of people that have to appear that day. So you just want to make sure that you are going to be taking account into potential traffic, potential travel time, just to make sure that you are on time because of the consequences of not appearing for your immigration court hearing. There's usually a security line that you have to make it through. Once you get through there, you have to check in with either a clerk or someone inside the actual court facility, and then you will be taken, you will arrive into your actual room that you're assigned to go into. Usually these are assigned by alien numbers. Again, that A number is super important to know. And you appear there, and it could be many people that are in that room with you. It might not be very many, really depends on the situation. And inside the courtroom, there should be a judge. There should be some sort of interpreter if you need Spanish, for example, translation, or if some other language, there should be an interpreter there potentially. And you might also expect that you could have to appear multiple times before the same court, depending on your situation and how it's going for you. So you might expect some of that as well.
That's really good to keep in mind for anyone going through this process. So regarding the number of hearings a person in removal can have, how many hearings can a person have? What is the time length for this? Does it usually take a long time, or is it a quick process? Can you share some insight on this?
Yes, in reality, you could potentially have multiple appearances before an immigration court judge. The first initial appearance, it's called a master calendar hearing. So this is usually your time itself will be probably pretty short before an immigration judge. They're going to, read the charges against you. Hopefully you have an attorney representing you at that point. And that's called the initial master calendar hearing. And again, there might be tons of people in there doing the exact same thing. Your appointment might be at 8 a.m. in the morning, but you might not get called until much later on, but you have to stay there and wait until you're actually called. And that would be the initiation, very initial one. And the judge might also ask what kind of immigration relief you'll be seeking. So again, having an attorney or someone representing you, super important at all of your hearings. Now, if you potentially don't have an attorney at that point in time, you are able to ask for a continuance in order to look for an attorney at a later, to hopefully be able to attend with you at the next court date. But after that, you might have multiple appearances depending like on status hearings, like what's going on with your case, for example. And the very last hearing that you might be expected to attend would be called an individual hearing. And this is basically sort of where you're going to present all of the arguments as to what immigration relief you're seeking, whether it's asylum or cancellation of removal or whatever the case may be that you're seeking a relief from. And if it's granted, that individual hearing is when that will happen. And again, that could be several months, it could be potentially years between the initial master hearing and the actual final hearing, which would be the individual hearing.
That's great to keep in mind that there could be more than one hearing, and we do need to take that into account and take a look at what we have in front of us. So what happens if someone doesn't show up to this hearing? Can you share some insight on that? Are there any consequences?
Yeah, so I mentioned earlier, yes, that there are consequences for not appearing before the judge, and this could be for any of the hearings, whether it's your master calendar hearing or a case status, or the last individual hearing that you have potentially. Not showing up to immigration court has severe consequences because the judge will issue automatically what's called an in absentia order of removal. This is an order of removal that you might get in your absence, which means that it just basically, by the pure fact that you did not show up to an immigration court hearing, that's sufficient to actually issue that removal order against you, which is quite unfortunate. So always show up to your hearings. If there's any reasons why you might not be able to show up for a future hearing, asking for a continuance, being able to get those motions in, especially through an immigration practitioner, immigration attorney, to be able to get that done on time would help save you from having an in absentia order by just not showing up. So never not show up. There are other options.
That's great to keep in mind. So you mentioned that the court offers some kind of extension if you don't have an attorney yet. Can you touch on that? Are there any special rights that a person has when they're going through this process? Do they have a right to an attorney similar to criminal court, or how does that process look like?
Yeah, so it's not similar to criminal court in the fact that you don't generally have a right to an attorney. You have a right to look for one, but you don't necessarily, you can represent yourself, right, before an immigration court judge. So you can appear by yourself and do that process on your own. However, it is very complex, and it's usually much preferable to have a really experienced immigration attorney who does removal, who can be there with you to support you and file the proper motions. The continuance that we were talking about earlier was really during the initial proceedings, such as the master calendar hearing. That's when you can ask the judge, hey, I don't have an attorney yet. I need some time to find an attorney. That would be at the initial outset. Obviously, a judge may not give you too much time, or if you don't show up with an attorney the following time, they might not give you any more time to look for an attorney at that point. But you are able to ask for that in the very beginning. You also have a right to make sure you have an interpreter so you understand what's going on. So there should be a competent interpreter in the room as well to help translate for you if you don't speak the language and you're in those proceedings.
Wow, that's really helpful information. Thank you for sharing all of that with us. So what happens during an individual hearing? What does that look like? Can you give us some insight on that?
Yeah, so the individual hearing, as I mentioned earlier, is really the final hearing that you might have before an immigration judge where you're going to present your case. Whether, again, it's cancellation of removal, where you've been in the United States for a very long time, you qualify, there's going to be extreme and unusual hardship on your U.S. citizen or legal permanent resident children or spouse and yourself, etc. Depending on what the relief is you're seeking, that will be the final stage at which you're going to be requesting that relief. Maybe there might not be a whole lot available for you, maybe not asylum, but potentially you could request for a voluntary departure, which is a form of immigration relief where you would have to depart the United States. So that all happens at that individual hearing at the very end. So it would be the final hearing in your case.
Good to know. So typically, I'm sure you've seen a lot of these cases. So what are the typical possible outcomes that we can expect during an individual hearing? What does that usually look like?
Yeah, so if you are, depending on, again, on your situation and your background and your forms of available relief, there are several things that could happen. One is the termination of your case. And when a case is terminated before an immigration judge, generally that could be a positive thing because it means that your relief was granted. So let's say you had a U visa pending while you were in removal proceedings. That U visa was approved. You no longer have to finish your removal proceedings because you have an approved visa now that you can, lawful status, and you can seek green card in the future. You can use that to terminate your proceedings before an immigration judge. And if those proceedings are terminated, that's wonderful because you'll need to have them terminated before you seek your lawful permanent resident status. So that's a good outcome to have a case terminated. The other potential options could be that your relief that you requested was granted. So let's say you applied for asylum, your request for asylum was granted by the immigration judge, or you requested cancellation of removal or some other form of relief before the immigration judge, and that relief is granted. So that's another great outcome. And again, that would cause your case to also be terminated. The other potential outcome could be that your case is administratively closed. Now, an administratively closed case does not mean that you are no longer in removal proceedings. It just means that your case has been closed. You're not being called to appear before the immigration judge, yet you could be called to appear before the immigration judge at any time in the future. Now, why someone might want to do that is because they might have other potential immigration relief pending before the United States Citizenship and Immigration Services, and they might have to have that case closed in order to get those approvals through the United States Immigration Services, and so they have to close those cases. So that could be another option because you might have other things going on that could help your case, in which situation you might require your proceedings to be closed administratively. Now, if they're closed administratively and you have options in the future, though, that case does have to get reopened and terminated again in order for you to seek that relief outside of immigration court. Second to last but not least would be removal proceedings. If you are actually given an order of removal by the immigration judge, that means that your relief was not granted. It means that you have to depart the United States, you have that removal, and you have that potential bar, that 10-year bar, unless you can get some sort of waiver or something outside of the United States. But that is a removal proceedings that is essentially what folks call a deportation order. So unfortunately, that's one of the worst case scenarios. The other relief that I mentioned earlier is the voluntary departure. And again, voluntary departure is not a removal order, but it does mean that you have to depart the United States. And the United States immigration judge will give you a certain amount of time for you to depart the United States. If you successfully depart, within that period of time, that does not convert into a removal order. However, if you fail to depart within a certain amount of time, that voluntary departure, that relief that was granted to you, could be converted to an actual removal order. And so actually it will be converted into a removal order. So not departing by the allotted time. And this is because voluntary departure is a benefit that you can request, and it's only granted once. Not only that, you have to qualify by not having committed certain crimes like felonies, and so it's considered a relief that's granted. So you can only use it one time. So important to that if that is something that you are given and you don't have any other options, it would be helpful to be able to do that so it doesn't convert into a actual removal order.
Wow, that was incredibly valuable information, Angelita, to give us an idea of the bigger picture and what our options and possibilities will look like, or what they could look like in this process. So thank you for going into detail about that. So you mentioned there could be different possibilities for this. So how can people stay informed about their case in the immigration court? How can they know what the progress is and where their case is at?
Yeah, so I mentioned earlier, really knowing your alien number, and you want to know that alien number because that is the number that you can use whether you're checking online on the EOIR website or you are, calling into the immigration court or the EOIR telephone number, the 1-800 number. That's the number that you will use to be able to check the status on what's going on, whether maybe a motion that was filed was actually granted by the judge or received, for example. You'll want to have that 1-800 EOIR number, and I can give it right now. It's 1-800-898-7180. That's an EOIR number that folks can call to check in on their using their alien number to find out date and time of hearings, locations of hearings, decisions again on motions that were filed before an immigration judge. Super valuable to be able to do that through your alien number.
That's really good to know. Thank you for sharing that number with us as well. So to close this off in a few minutes, any final advice for anyone who's going through this process, or has anything happened recently on this topic or in the legal world that we should be aware of? Any final words of wisdom for us?
Yeah, I would say some final things is definitely be aware of your hearings, attend your hearings. Also, if you change addresses, you have to notify the immigration court as well as DHS, the OPLA, about your change of address. And because if something happens and your case, your date is changed or whatnot, they need to know that information. So notifying them through an E33, and if you have something before USCIS, also remember to file your AR11. We did a short video on that, and filing your AR11, which can be done online, and that's with the United States Citizenship and Immigration Services. So, always be mindful of those things. Talk to an experienced immigration professional, immigration attorney that can assist you in filing motions to an immigration court, especially if you have to change venues. Let's say you move states and now you're going from LA to Washington State. You're going to have to change that venue from Los Angeles to Seattle, and you're going to have to file a motion before a judge so that, and if they approve it, then you would be able to now continue your hearings in Seattle where you actually live. So that's just a basic example of things to just keep in mind: changing addresses, changing venues. And also one final thing is, being super careful with notary fraud, or folks that are not actual not actual immigration attorneys or accredited representatives that work with nonprofits, because there are a lot of, unfortunately, folks out there that do prey upon the most vulnerable, and this could be folks that are in removal proceedings, and they might charge thousands of dollars. They say that they're attorneys, they're actually not attorneys, and then they will never appear before your removal proceedings to show up, and they don't show up. Unfortunately, that does happen across the country quite a bit. So calling different attorneys, getting those questions answered. This is part of the reason why we love doing these live chats, because we want to inform people of the basics. So at least you have enough information to empower yourself to ask the proper questions when you do decide to hire an immigration attorney.
That's such great advice, Angelita. And thank you for sharing your insights with us, and for stressing the importance of that. It is so important to get to know your attorney, make sure you feel comfortable with them, make sure they're actually helping you out, and just really connect with them on a deeper level to make sure that they're going to help you out through this process and not abandon you at the last minute. So definitely important to keep that in mind and get to know your attorney. Thank you, Angelita, for your time and stressing the importance of all of those things. That is all we have time for today. So this does bring us to the end of our conversation. Thank you so much, everyone, for joining us today. A special thank you to you, Angelita, for your time and sharing your insights with us. To make sure to stay up to date with us, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If this video was helpful, please make sure to give it a like and subscribe. Turn on the notification bell so you can be notified of our next upload. And if you have any questions or suggestions, or want to tell us what topic you want to see next, please email us at info@truth.com. We'd love to hear your insights, and join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you for joining.